managing who is our managing attorney of our family helpline. Um, Nikelsia, did you or Cindy want to talk about how we're going to work the chat, or did you want me to do that?
Sure, no problem. So if everyone does have access to their chat, please feel free throughout the presentation for any questions that you do have to put them in the chat. We will have Cindy who will be answering the questions as you all may have. And then about 15 minutes toward the end, we're going to stop the recording and be able to give you all an opportunity to be able to ask questions.
All righty. So I wanted to thank Nikelsia and Audrey for allowing us to present today. We're real excited about it, and I think everybody should know at this point, but this is the first of a series of three. The second one is going to be on public benefits, and the third one is going to be on um, court cases. So we have a lot to talk about, so we'll get started on non-parent authorizations. So as we introduced ourselves before, I am Nicole Love. I am the kin care attorney with Texas Legal Services Center, and our kin care project just started about a year ago. So we are up and running, and Cindy Dyer is the manager of our family helpline and of our kin care project. We work for Texas Legal Services Center, who's founded in 1981. We're a statewide nonprofit organization that provides legal advice, advocacy, representation, and education. We have 12 plus service areas. So that's just a brief overview of some of the things that we do. And I just put in here a brief agenda so you would just have some idea of the things that we were going to discuss. I am going to send Nikelsia a PDF of the presentation today. So if you need to get a copy of the slides from her, she can always send that to you. So I wanted to start out with a quote from a client because I thought um, it was really relatable. And she really said so well what kinship caregivers go through, what challenges they have. She said, taking in young grandchildren at this stage of life is extremely exhausting and rewarding, but without financial support and support in how to navigate all that involves, it's extremely daunting. There are many days I just want to give up, but I can't because these kids need a happy and stable home. So the first thing that we want to do is talk about parents' rights. And why are we starting with parents' rights? Because that is the basic foundation. Um, when you're talking about the familial relationship and you're talking about law. In Texas, a parent has rights over anyone else unless there's a court order that says otherwise. This includes rights and duties to have the physical possession of the child, so the child with you, uh, the right to choose where the child lives, the right to choose, make religious choices, make sure that the child goes to school, doesn't break the law, protect the child from abuse and neglect, to discipline the child, support the child with food, clothing, and care, and consent to any other kind of care that they might need. The important thing to remember too is that if there are two legal parents and no court order, then they each have equal rights to the child. And I wanted to emphasize legal because that is sort of the key. So who is a legal parent? Mom. And that's a pretty easy one to figure out. She's either born, she's either had the child herself or she's adopted the child. Fathers, however, have to take an extra step to become a legal parent. they have to establish what is called legal paternity before they are considered a legal parent. So how can they do this? They they can be acknowledged, which means they're on an acknowledgement of paternity form, or they have signed off on a birth certificate. They are presumed, which means the parents are legally married at the time the child is born, the child's born within 300 days of the marriage, or the man has lived with the child for the first 2 years of his life and told everybody, this is my child. Um, or adjudicated, which usually involves a DNA test and a court action in which a judge would sign an order saying that the man is the father or the man adopts. You find a lot of times fathers are adjudicated if there's a child support process going on with the Attorney General's office. They may do um, a lot of DNA testing and court adjudication. And a lot of times it might occur in a CPS case as well. But it can also be a paternity case that's brought by the father. It's important to know in regard to the man whether or not he's a legal parent, because that would indicate whether or not he has rights and duties that a legal parent would have. And by extension, unless he's a legal parent, his parents may not be legal grandparents until he does something to become a legal parent. And a kinship caregiver is not a legal parent. So, why is this important? Because if you are not a child's legal parent, you cannot make decisions for a child unless there is a valid legal document or court orders giving you authority to make these decisions. So, you or someone you know may have run into possible problems when there is no decision making ability. You may have problems enrolling this child in school, with special ed, with discipline, may have trouble getting medical care or dental care or counseling, applying for public benefits, or trying to obtain copies of a birth certificate or social security card. And in a nutshell, I had a client who said it all. It's hard caring for a child with no rights or make all decisions to properly care for them. So if you're not a legal parent, how can you make these decisions for the child that you're caring for? I like this one. You get permissions. Everybody gets a permission. So that's the key, permissions. So there are 3 formal tools for getting these permissions, and then 1 informal tool. And so we're going to talk about all of those. And that's a lot to go through, I know, but it's all really important. So to help kind of illustrate or help you understand what we're talking about and how these work, we wanted to give you an example that you could keep in your mind when we're going through each one of these. And then we're going to talk about how these might or might not apply. I'm hoping that what it'll do is give you a better understanding of the options that are available and how we sort of figure out what might work or what might not work. So in this example, CPS has called grandma and asked her to keep her 2 grandchildren. Her daughter Susie is 16 and she wants to get her driver's license, but she needs a parent's permission. She would also like to go on a school-sponsored international trip, but she doesn't have a passport. Susie's dad is unknown. Joe, who is 7, has ADHD and takes medication, and he's almost out of his medication, so he needs to see the doctor so he can get it refilled. His dad is on his birth certificate, but he is incarcerated. So after CPS asked mom to leave the kids with grandma, mom left and nobody knows where she is. CBS has told grandma, though, that because the kids are in a safe place, they're going to close their file. And that is a pretty common story. So the first thing that we look at is whether or not there might be this ability to get what is called the Texas Family Code Chapter 34, which is an authorization for non-parent care of a child. And that's, you'll hear that oftentimes um, referred to by lawyers in particular as just a Chapter 34. Or some people even will call it an NPA, a non-parent authorization. But basically what this is, it's a voluntary form signed by at least one legal parent and a chosen caregiver that gives permission for the caregiver to make certain decisions if the parent can't. And I wanted to, and I realize it's kind of small, but I really couldn't get it any bigger. To give you just sort of an idea of what this would look like, this is the first page
There's something there when I was sitting down. So let me give her more.
of this form, um, so that you'll see sort of what it looks like. It's pretty basic and self-explanatory. But what permissions can it give? It basically gives permissions for medical care, education, wellness, and identification. But it does also give permissions for things like to get health or auto insurance for the child, let them participate in extracurricular activities, allow them to get a learner's permit, driver's license, or state issued ID, let them get a job, and then permissions, to obtain public benefits and get ID documents. A legal parent can give any or all of these permissions. And we're going to emphasize legal parent a lot because that is the key. So what permissions cannot be given? You can't give permission for an abortion. They can't give permission for an emergency contraceptive medication. They cannot, immunizations, if a parent says no, then it can't give that permission. And it cannot give permission to get a passport for the child because that is a federal law that says that they cannot do that. And federal law trumps state law when you're talking about legal stuff. So who can be authorized to be a caregiver? Any parent, any adult the parent chooses, as long as that person agrees. So it can be a teacher, it can be a minister, it can be a neighbor, it can be a family member, as long as they are over the age of 18, so they have to be an adult, and as long as they will agree. It's important to have a conversation so it will be made clear whether or not somebody agrees. Sometimes somebody will say, well, I know that they'll do it. But unless you have that conversation, you won't know. And that's important because both people have to sign off on this form. So the requirements under this form are that the child has to be under 18. There's one form per child. You have to put in here basic information about the parent or parents and the caregiver, like their contact information, their telephone number, things like that. The caregiver to be named has to be a legal adult, so over the age of 18. Sometimes we get asked, well, but there's a sibling, there's maybe a brother or sister that's about to turn 18. Can they do it? The answer is no, not until they turn 18. It has different warnings and disclosures. There cannot be court involvement with the child, and we'll get to that and explain that more in a minute. There can't have been one of these that was previously signed and not properly revoked. It has mailing requirements. There's a length of time, and we'll go over that in a minute. And then it's required to be signed by both, at least one legal parent and the caregiver in front of a notary. And so you have to, when you're signing, you have to swear that this is voluntary. So why do we ask about court orders and other permissions? The reason that we ask is because the law says in certain situations that you cannot sign off on a Chapter 34. If the child is or has been the subject of a court order or pending litigation. And what has to happen if that's the case is that, and what that means is basically if there is or has been a case where, like, maybe the parents have gone to court for child support, divorce, custody, or there was a CPS case, where there was a final order that was entered, or if there's something happening now, then the court has to give permission for the parent to sign. If you don't get that permission, this authorization is void. And possibly it could be used in a criminal context. If they don't say that that's the case and then they sign off on it, there is the possibility that someone could be charged with a Class B misdemeanor. And you are swearing to the truth of what you're saying in this authorization before a notary. And this is because the court ultimately has the authority over the child, unless the parent's been specifically given permission to make certain decisions. Another reason why someone couldn't sign an authorization, the law says that it can't be signed if somebody else has actual physical possession, or somehow this is inconsistent with what you're asking with what is permitted. So let's say, for example, CPS has the child, but a parent wants to come in and go, yeah, but if I just give authorization to my parent, then that will go away. That's not necessarily true. And so you have to pay really close attention to that. If there is a pre-existing authorization like this and it hasn't been properly revoked, then you can't sign off on a new Chapter 34 because the old one will still be the valid one. So these can be revoked, but they have to be done properly. So they have to be done in writing, and people have to be notified of that. So if one of these is an issue, if one of these is an issue, then it might be best to talk to an attorney or get somebody who can give you some more information on what options exist to sort of get over these hurdles. So the warnings and disclosures, I wanted to go over these because these are very important. An authorization like this does not give temporary custody or guardianship to anybody. We hear that all the time. We have people call and say, well, I have temporary guardianship, or I have temporary custody because I have this authorization. And then I have to explain that that's not the case. This is a permission slip. It basically tells you you can make some decisions if the parent can't. It is not a court order, so no parental rights are transferred. And so what that means is, we talked about before that a parent automatically, unless there's something that changes that, some court order, they have certain things that they're able to do for their child, certain rights and duties that they have. This authorization doesn't transfer those to the person that's named in here as the caregiver. It just gives permission, which can be taken back by the parent or can be revoked by the caregiver. So it is a permission slip, but you can't go to court with it. You can't say, well, judge, because I have this authorization, I'm able to keep the child in my possession, or I'm the one that gets to make the choices. The court is going to tell you that is not what that means. It is simply a permission slip. So all those rights and duties that a parent has remain with the parent, even though there is one of these in existence. Again, this just gives permissions. It does, however, warn both the parent and the caregiver that the parent's parental rights can be adversely affected by allowing the child to be left with the caregiver. And that's because if there's a custody case that's filed because maybe the parent or parents haven't been around for a long time, so the caregiver decides that they're going to go file for custody, um, the court can take this into account. Unless a parent is supporting that child somehow or keeps in contact with everybody, then potentially this could be used like that. It also cannot order the parent to pay child support. The parents still have that parental obligation to continue to support that child and have communications and have a relationship. But until you get a court order that says that there's child support that's been ordered, a parent doesn't have to legally pay anything. It does also state that the caregiver is responsible for some expenses. Now, I haven't been able to find any legal authority as to what some expenses actually means, but that is probably, I think we can all presume it's something, it's at least as simple as food, clothes, and making sure they get medical care, things like that. Um, so, but that would be something that someone as a caregiver, we would hope that they would do anyway, because you're wanting to look out for the child's best interest. So you're going to want to take care of them. It does not mean that this can't be revoked. Either the parent or the caregiver can revoke it in writing at any time, meaning they can take back their permission. And this is important because if the parent comes to pick up the child, then the caregiver has to return the child to the parent unless there's something else that says that they can't, like a court order or a CPS safety plan. And even then, there's potential for the parent getting the child. They just may not be doing what CPS wants. So if there's concerns, if a parent comes to pick up the child, a caregiver can contact the proper authorities or contact an attorney about options. Because if the child's not returned, then the parent can file a lawsuit to get the child returned. This permission automatically renews every 6 months if it's not revoked. And again, it can also be a crime if a person knowingly presents a document that is not a valid authorization agreement or makes a false statement on the authorization or gets the authorization by fraud, duress, or misrepresentation. And duress is, if you're trying to pressure someone to sign something that doesn't want to. Have I ever heard of anybody that's ever been charged with that? I haven't, but that doesn't mean that it can't happen. So it's really something that should be complied with. So going back to our example, we need to know if grandma can get a Chapter 34 authorization for either of these kiddos with the information that I've given you and the facts. So remember, Susie's 16, she wants to get her driver's license. She doesn't have a passport. Her dad's unknown and mom isn't located. And Joe is 7, he needs to see a doctor so his medication can be refilled. His dad's on his birth certificate, but he's incarcerated. Mom isn't located. Can grandma get a Chapter 34 authorization for either of these kiddos? And I'm going to give you just a second to sort of think about it. So is there anybody, and you can take your mute button off for just a second. Is there anybody that says yes or no, or you just not want to answer? It's okay either way.
No.
Are you talking about for Susie or for Joe or for both? Let's talk about Susie. Can grandma get a Chapter 34 for her?
No.
No.
And why is that?
Because it's a permission slip. It don't allow us to give authorization for passports.
Well,
Well,
and that is
you also don't have a parent that can sign it.
exactly. There's no legal parent that can sign off on the form. For Joe, grandma could get a Chapter 34 because she could talk to Joe's dad, even though he's incarcerated. If she's got some sort of relationship with him, she could talk to him to see if he would be willing to sign off on the form. And if he does sign, then that form automatically renews every 6 months until someone revokes it. So what can you do if you don't know where a parent is, you don't know who a parent is, or they won't necessarily sign off on it? They're just not doing anything at all. So there's this option for consent to medical treatment by a non-parent under Texas Family Code Chapter 32. And again, this is because parents have the duty to provide a child with medical and dental care and the right to consent to medical and dental care. And under this section, there are certain people who can consent to healthcare treatment of a child when a parent can't be contacted, and if that parent has expressly not told anyone that treatment can't be given. And it's just a form. And again, it specifically allows for certain people to okay medical, dental, psychological, and surgical treatment of a child if they can't contact the parent and that the parent hasn't said the treatment can't be given. Who can give this permission? Not everybody. A grandparent, an adult brother or sister, an adult uncle or aunt, someone who's actually has the child in their possession and already has a written something from the parent saying, okay. If they're under a juvenile court can give permission, and then some other agencies. When can you not give consent? If a parent has specifically told you that they don't want you to consent, they said, okay, I'm going to give you consent, and then they took it back, or they have specifically said, I don't want you to give consent for immunizations. And this is what the form looks like. Again, you can see it's pretty simple, and I'm sorry, again, it's so small, but it includes the name of the child, the name of the both parents, the name of the person giving consent, the relationship to the child, what kind of medical treatments to be given, and the date the treatment is to begin. So pretty simple. Certain children can also give their own permission or consent. And I highlighted the ones that come up most often. So if you've got a 16-year-old who's living apart from their parents and they're managing their own financial affairs, they can give their own consent. If they want to consent to diagnosis and treatment of an infectious, contagious, or communicable disease, so if they wanted treatment for COVID, they could consent to that. If they're unmarried and pregnant, and they want to consent to some hospital, medical, surgical treatment, something other than abortion that's related to their pregnancy, they can consent. And then you guys can see there's some other children that can give consent, but these are the ones that we see the most often. If they are giving their own consent and they're allowed to do so by law, an adult does not have to give permission. And we've had issues where somebody's gone to a doctor's office or and their front desk personnel says, well, no, I need one of their parents. They may not know or understand what the law says. So a lot of times when I'm doing that, I will send someone with an actual copy of the law, or sometimes if you just have them ask, like maybe their office manager, or if you're in a hospital, most of the time they already have a policy in place for that. So just, make sure you ask about it if they say no. Uh, um, if you're wanting information and the child gave their own permission, you cannot really get it. A doctor, dentist, or psychologist can advise the parents or someone with legal custody or guardianship, which goes through a probate court. Otherwise, they are not really supposed to give out that information. The child can sign their own consent form. And it's really important to know that if there is a reasonable belief of abuse or neglect, that a child can be examined without the consent of anybody, unless they're 16 and they refuse, or unless there's a court order that says that that cannot happen. They can consent to their own counseling if it's for suicide prevention, substance abuse, dependency, or sexual, physical, or emotional abuse, unless there's a court order that says no. And then if the child consents for those things and the caregiver is not the one consenting, then they're not responsible for payment. And what about immunizations? There are specific adults that can give permission for those. A grandparent, adult brother, sister, adult aunt, uncle, a step parent, a school under certain conditions, and an adult who has written consent, unless the parent has refused to give the consent, told you as the caregiver not to give permission, or gave it and then took it back. As a caregiver, you would have to give the health provider a health history so they can determine the risks and benefits of giving an immunization. And a child can give permission only if they are pregnant, or if they're the parent of a child, they have actual custody of that child, and the CDC has recommended or authorized that immunization. So again, we're going to go to our example. And Susie wants to go to counseling. And remember, she's 16, to deal with abuse that occurred while she was with her mother. Remember, her dad's unknown, but mom's not around. Joe is 7, and again, he needs to see a doctor so he can get his medication refilled. His dad's on his birth certificate, but he's incarcerated. Mom, we can't find her. So can grandma get either of the kids' care? What about Susie? Do you guys think that she can give consent for that based on this law?
And some people are responding in chat just in case, but
Okay.
saying yes or yes for Susie, Joe, yes. So yes, in chat.
Okay. So this is kind of a trick question. So grandma could get consent, but Susie could consent to her own counseling, right? Because she's 16 and it's for one of those categories of things for abuse. For Joe, grandma could sign a Chapter 32 consent to medical treatment. Because remember, all she has to do is sign off on the form. So what would happen if dad told grandma that he didn't believe that Joe needed ADHD medicine, and he specifically told grandma, I'm not I'm not agreeing to that. I'm not agreeing to that. And or maybe mom at some point told grandma she's not agreeing to that. Could grandma still get ADHD medicine for Joe? Right. She could not. Okay, because someone has expressly said no. Could she get medical treatment, say, for instance, if he had an ear infection and he needed tubes put in his ears? Yes, she could do that, but she would not be allowed to ask for the ADHD treatment or medication. So the next one that we're going to talk about is Texas Family Code Chapter 35. That is a temporary authorization for care of a minor child. This is a lawsuit that can be filed by the caregiver if a parent can't be located or doesn't respond to the caregiver. So if you are asking somebody to sign off on an authorization and they're not just not responding at all, then this is something that might be an option. And here I just put in a really brief picture of the top part. You can see that this is a lawsuit that would be filed in court. And who can file this kind of lawsuit? A grandparent, an adult brother or sister, an adult aunt or uncle, or an adult who has written authorization for medical care. So you have to be caring for the child in your home for at least 30 days, and that is key. You don't have a parent or anybody else that's available to consent to things or authorize care, and it's called necessary for the child's welfare. What specifically is necessary for the child's welfare? Basically anything that's good for the child. So even if you're talking about something that's good for their mental health, um, it could be considered by the judge to be necessary for their welfare. And I'll give you an example in a minute. You can file it if you're one of those people and you need a court order that gives you the right to do things like consent to medical treatment, obtain public benefits, enroll a child in school or daycare, authorize extracurricular activities, or authorize other care that again is essential to their welfare, and you're unable to obtain a written or some other document from a parent. And again, and sorry, I forgot to put do. What can and can't it do? It can do all of those things, but it's really up to the judge to determine what he or she is going to allow. So, and they cannot again authorize a passport application. So, an example of this would be perhaps a child who maybe wants to participate in a special outside of school club for whatever reason, but needs a parent's permission and nobody can find the parent. So the organization might be one that says, well, we need some sort of court order if you can't get a permission. So could someone in that particular case, if they meet the other requirements, go to court and file this kind of petition to ask for specific authorization for that child to participate? Yes, especially if it's for a good reason, like they want to, use it to put it on their college application or something. However, again, by virtue of that, some people have come to me and said, well, but this child's been in my home and I want them to be a part of the family and I want to take them, on a cruise or whatever, but I have to have a passport. The court cannot authorize a passport application for the caregiver. So things to remember when you're considering one of these is it is a lawsuit. It's not just a form. So you have to provide information. You have to file it with the district clerk. You have to give notice to a parent and either serve them with the papers or have them sign off on something that said they don't need a deputy or a police officer to come give them the paper, and you have to go before a judge. So it could potentially require money if you have to pay for filing fees, which you can file something called an affidavit of inability to pay. That means that the district clerk's office might say you don't have to pay those fees, but that may or may not always be the case. And it will cost you time because it is a more complicated thing to do, and it will require you to go before a judge. Again, this does not give anybody temporary custody. It is a court-ordered permission. So if a parent objects, the law requires that if it's in court, that the judge immediately dismiss it. There is no hearing about whether or not, the parent hasn't been around and, well, I've been the one that's making all these decisions all this time. And the court doesn't have a choice. The law requires that it be immediately dismissed. And if the court's already granted it, if the parent files, or says some kind of objection, they can file, and if they want to object, they can file a motion for termination of the order, and the judge will have to grant it. It does expire after 1 year, so it does require yearly renewals. So it can cost money. It can take time, but it can do what you need it to do. You don't have to hire an attorney, but it might be one of those things where you at least want to talk to an attorney about it to make sure that this is the right option. So going back to our example, Susie, who's 16, wants to get her driver's license. She wants a passport to travel. Remember, her dad is unknown and mom isn't located. Joe, who is 7, needs to see a doctor so he can get his medication refilled. His dad's on his birth certificate, but he's incarcerated and mom isn't around. Can grandma file a Chapter 35 petition for temporary authority to care for the minor child? So if we're talking about Susie, let's start with her. Can grandma ask the court through one of these petitions for a permission? And sorry, I can't see the chat, so I don't know what people are saying.
There's one just outright no, and then another one, yes to the driver's license, no to the passport for Susie.
That is absolutely correct. So she could file and ask the judge to order that she have the authority to okay the driver's ed, because that would be considered essential to her child, to her welfare, or could be, say, for instance, if she tells, if she says, well, I want to go get a job, and that would enable me to be able to drive to and from work. But again, because of federal laws, grandma would not be allowed to apply for a passport. So we're talking about Joe. Could grandma ask for authority from the court under Chapter 35 to take him to the doctor? Yes.
Getting some yeses in the chat too, yeah.
Okay. And so what if Mom shows up at court and says, I'm sorry, Grandma, I don't want you to be making this decision or these decisions. What has to happen then? Can she go forward? No. The court has to immediately dismiss the case. So the last thing that's a possibility is something called an informal power of attorney. And this is basically a handwritten or typed document that's drafted by the parent or caregiver, giving the caregiver authority to do whatever they want to say in that document and signed off by the parent. Does it have to be notarized? It's recommended. The problem with these informal type things that are not on that form are that because that form was actually put together for use by CPS, but also for anybody else who wanted it, they did that to make sure that all the legal requirements were met. When somebody just does one of these informal ones, that may not be the case. And so there are some schools, some providers, medical and otherwise, some agencies that may not accept this type of informal power of attorney. But if you're trying to get something from a parent and you need something in a pinch, it may help you with whatever it is you're trying to do, or it could potentially help you when you're trying to find one of these alternatives to use. But it's not something that an attorney would probably recommend. So where can you find information, guides, self-help kits, forms, resources? TLSC runs Texas Law Help for the state. And what that is it's a website that you can go to, and it has a ton of information. You can just type into that search bar if that's easier, or use one of the drop-down menus. And you can read up on these different things again. They have it in really, big print, question and answer type formats. And there are some self-help guides and forms and instructions in Texas Law Help. Some law libraries, some court personnel might be able, like a DRO might be able to help with some of these things, maybe not. There's also, though, the opportunity to live chat with a family law attorney between 10 and 2, Monday through Thursday. So there's also that possibility. At the bottom of the website, there's a little sort of person you can see, it's a circle, it jumps up and down. And when there's that, then you can chat with a family law attorney. There's also a button that you can press for resources in your county. So that can be really helpful as well. There's my project, which is the Kin Care Project, and we can help non-parent caregivers with a lot of these things, or at least give you some legal advice, but you have to qualify because we're under a grant that does make people qualify for us to be able to help them. So we don't discourage anyone from applying. So we have our email there if you'd like to apply, or you can call, and we have a dedicated voicemail line where you can call and you can leave us a message, and we'll put you back on our callback list so that we can do a screening intake to see if it's something that we can help you with. Sometimes we can just give you resources. Sometimes there are different organizations that are also on our same grant. And we might, if we can't help you, be able to directly make a direct referral on your behalf to another organization. So we can send them information if you give us permission, and then you don't necessarily have to contact them yourselves. We also have the family helpline that's available. And that is for information regarding specifically CPS case services or cases. So anybody can call that has a CPS question. It's not just a parent. It can be anybody that may be involved or have questions about a CPS case. They're open 9 to 6, Monday through Friday. That's their number. You can call anonymously. You don't have to use a specific name. There's no income requirement. And we get calls from parents, grandparents, neighbors, court personnel, schools, counselors. So if you have questions, you can call. They cannot give legal advice, but they can give you legal information. And I got done faster than I thought I would. So are there questions that Cindy hasn't already answered?
Nicole, I do have one that I wanted you to confirm.
Okay.
If both parents are deceased, are there any authorizations available for a grandparent caring for their grandchild?
So if they're deceased, they can, there wouldn't be anything obviously that a parent would have to sign, right? So potentially, could there be that authorization that they could use for medical care? Or could they go potentially get a Chapter 35? Potentially, yes. In those situations, someone might want to consider a custody suit, but again, that's not always what someone wants. And that may be more complicated than they're wanting at the time, but those other options might be available depending upon the other circumstances, but obviously they can't get something that a parent has to sign.
And that was the only other question unanswered in the chat.
Okay. Does anybody else have any other questions at this point?
We'll stop the recording.
Oh, yeah.
Right? So that way anyone